This motion to revoke bond, and that's, the DA's office here always styles it that way, but they leave off the other options. It's a motion to revoke, alter, or amend. So this thing that's been handed to you is now an exhibit, is maybe sufficient to show that the bond condition has been violated, but the court has discretion on what to do with it. And so I think that's where we are. So if the court is now ruling that they have sustained that the bond condition has been revoked, then we'll go to what needs to be done.
Well, based on that case that Mr. Stevens has referenced, is in my own understanding of the current state of the law, a certified copy of a subsequent arrest record is admissible, and under the statute that the state is proceeding under, they have the right. It doesn't require conviction. It says anyone who is on bond or in bail and is arrested on a subsequent offense, that the court has the option of revoking their bond. So
Yep.
I think that the state has met its burden to show that there is a basis for the court to consider any revocation of the bond, or as you state, the statute allows for modification of the bond. So the state, in my opinion, has met its burden to show that there is a basis for review of the defendant's bond, either a revocation or a modification. So if you wish to offer any proof about that, then I'll be glad to hear it. So.
Well, I guess my position is now, has the state put on enough just with that to justify a revocation of the bond? I mean, that's all the proof you have before Your Honor. So you got three choices. You can raise the bond. You can put different restrictions on her. So my position is they have not met the burden to show that one of these other options is not appropriate. So I'm asking the court, as a matter of law, to alter or amend the bond.
So you're basically asking me to alter or amend it, okay?
Yes, because I mean,
I understand what you're asking.
Yeah, they
So-
put that.
Let me hear what the state's argument is. If we're not going to have any proof, then I'll let you both argue what you think the appropriate disposition is.
Well, let's do it this way. State your name for the record and please spell it.
Shonda Vargas, it's SHONDA VARGAS.
Okay. Ms. Vargas, where are you employed?
Serenity Ranch Recovery in Mammoth Cave, Kentucky.
Serenity Ranch?
Yes, sir.
Okay. And has Ms. Miles already been admitted there?
Yes, sir.
And
Turn your microphone on.
a new charge you've already carried the burden on that, General. New charge has occurred. We're talking about disposition.
So just to clarify, is this, so as Mr. Flanagan seceded the point that his client violated the conditions of bond, and this is for the purposes of what to happen? Because at this point, I think it's irrelevant to whether or not she picked up new charges while on bond.
The court's already ruled in your favor on that, General.
I have ruled, as a matter of a finding that I've made, that the introduction of this certified copy is sufficient to meet the burden that the state has to show that there is a basis for the court to consider whether or not to revoke the bond. So I've made that finding. Mr. Flanagan is now wanting to produce proof that would offer alternatives to the actual revocation by offering, I'm assuming, some testimony that would indicate there is a basis for a modification of the bond, which is one of the options that the court has in this particular case. So as far as relevance, it is relevant, and I don't know, I haven't heard everything, but if it's relevant as to what the defendant's present situation is and what, if any, modifications should be made versus revocation. So I'm going to, unless you have some other basis for the objection, I'm going to allow it to proceed.
Yes, sir.
Tell the court about the program.
It's a 28-day detox and residential program where we help individuals overcome substance abuse disorders. And we also deal with mental health, so we are dual diagnosis. After the 28 days, we do help clients go to the next step, which would be a partial hospitalization program, a PHP. We do help them get that set up if that is something that they are interested in to continue their recovery, to help them in that sort. We have therapy, we offer therapy, case management, and things of that sort, also group therapy. It's just kind of to get them to go on to the next step in there.
Okay, and so she's been admitted,
Yes.
been there a couple of days, right?
I want to say she's been there about a week, but I'm not
Okay,
positive
about a
about
week.
that. Yeah.
And she'll be there for at least 28 days?
Yes, sir.
Could it be longer?
Not in our program, but we can set it up so she can go straight from our program to another program that would be 30 to 90 days.
Okay. And at my request, you brought her here today because you knew she had to be in court.
Yes, sir.
If she were to leave the program, would you notify me and/or the district attorney and the court that she left the program?
Yes, sir.
That's all I have.
Stevens, do you have any questions? You don't get off that easy. The state has the right to ask you questions.
This is kind of nerve-wracking.
Good afternoon, or good morning, ma'am. Just a few questions for you. So when you go through that, are you aware of any of her prior charges as part of this when she goes into a program?
Yes, sir.
Okay, so you're aware of about 20 prior domestic charges?
I mean, I'm not personally, because I don't do the admission part. I work with the clients on a daily basis. That's all. That's my job.
Okay, what about 20 prior charges for violating conditions of bond?
Again, that's not my job. I don't do the admission part. I just help the clients when they come in.
What about 5 times failing to appear?
Again, that's not my job. I don't work with the admissions. I don't know what we know about her prior charges, but I do know that she had charges because we brought her to court today.
Are you aware she's a convicted felon for aggravated assault?
I mean, most people there are.
Okay,
Yeah.
That's all that I have. Thank you.
Nothing further this witness.
Thank you,
If the
ma'am. You
court
may step
doesn't have
down.
any questions.
Mr. Miles, well, first of all, Mr. Stevens, are you intending to ask him about the factual basis of it?
I am, Your Honor.
Mr. Miles, you are the alleged victim in this case that's being used by the state as a grounds for the revocation of Ms. Miles's bond. In that, the officer who made the arrest is stating that you gave him information that, and I'll read this to you. It says, I made contact with Joseph Miles in front of the residence while Sergeant Mutter spoke to Rebecca Miles on the front porch of the residence. Joseph explained that him and Rebecca were eating Chinese food in Bellevue. Joseph stated him and Rebecca got into a verbal altercation at the restaurant. During the verbal altercation, Rebecca stabbed Joseph in the right hand with a fork. And then it also says that once you returned to your residence, Joseph stated that when he turned on Trace Creek Road, Joseph stated Rebecca started striking him in the face, chest, and groin. And I observed noticed a bruise under Joseph's right eye. So what Mr. Flanagan is wanting you to understand is that if you gave information to a police officer that they used in reliance on obtaining a warrant against your wife for domestic assault, and you are asked those questions today under oath, and you answer differently than that, there is a possibility that you could be subjected to criminal prosecution yourself because there's a statute that makes it a crime to give false information to a police officer. Sometimes people get mad and they say things to an officer, they make a false report. And the reason they make a false report is because they're angry, upset, or whatever, and it's not true. But sometimes people decide they don't want to really, have to see what happens, so they want to change their story. But you have to understand that when you testify today under oath, then those questions, those answers could be used as evidence against you if you change your version of what happened. You also, as a citizen of this country, have a right under the Fifth Amendment of the Constitution to decline to answer any question that might tend to put you in danger of criminal prosecution. You understand that? You understand everything I've asked, I've advised you
I
of?
can decline the
You can
question.
decline to answer a question if you think your answer could potentially put you at peril for criminal prosecution. You can decline to answer because your answer might tend to incriminate you in criminal prosecution. Do you understand that? All right, you understand everything I've explained to you?
Yes.
All right, Mr. Stevens, you may ask.
Sir, please state your name.
Joseph Miles,
And Mr. Miles, how do you spell that for the record?
Joseph Miles,
Mr. Miles, who is your spouse?
Rebecca Miles.
And how long have you been married?
It's about 3 years now.
3 years. What was her maiden name?
Rebecca Fane. Fain,
How do you spell that, sir?
Fain.
Did something happen to you on August the 1st that leads us to court today?
Yes.
And what was that?
We got in an argument at the restaurant.
About what?
She said that I was looking at a lady's butt, and I said I was talking about the bucket that had soy sauce on it.
Okay.
And she thought I was looking at the lady's butt.
Where was that at?
She
Was
got
that in
mad
Dixon
at me.
County or another county?
It was in Bellevue,
Davidson County, to your knowledge?
Davidson.
What did she do in response to that argument?
She hit me with a fork. I think that's what it was. I had my hand laying there, and she just hit me with it.
Did you have any marks from that?
I had a little scratch on my hand.
Okay, still there today? Still there today with a mark?
No.
Okay. Now, Mr. Miles, did you drive home after that?
Yeah.
Where'd you go to?
Went home
And where's that at?
on Trace Creek Road.
Is that in
White
Dixon
Bluff.
County?
Right in White Bluff.
Okay.
Dixon.
White Bluff, Dixon County?
Yes.
Now, on the way home, what else happened?
We argued, and it wasn't really a hit. She was just pushing, and I was kind of pushing away from her. And it was just a little altercation there, just back and forth.
Now, did you talk to an officer on scene?
Yes.
Officer sitting at court at a table with me right here?
Yeah. Yes.
Now, as part of that, what did you tell the officer happened?
I told him at the restaurant we had an altercation, and just had an argument.
Did you mention where she said she was going to slit your throat at bed
I think I might have mentioned that.
multiple times?
I think I mentioned it once.
Okay. As part of that, did you tell the officer that she hit you right up there on that hill, right at the hill you can see right here, which would have been in Dixon County? Did you tell him that?
It was on the hill above the house.
So she struck you while you were in Dixon County?
Well, we was pushing each other.
Okay. You aware she's on bond for a matter, correct?
On bond?
Correct?
Oh, yeah.
Involved striking a
about the
school
wreck.
bus, is that correct? Striking a private school bus that caught on fire?
Correct, yes.
And you're aware she's a convicted felon?
Yes.
You're aware that one of the charges was she had a gun in her purse?
That, I didn't know she had a gun in her purse.
You didn't know that?
No.
Were people from the family calling Officer Lewis asking for the gun back before charges were made?
Her son asked me about the gun. It was his gun.
Okay. In her purse, correct? Or you don't know?
I don't know if it was in her purse.
What pills does she take? What medication does she
That's
prescribed?
medication, oxymorphone, and something else.
And
for her back.
she'd have a prescription bottle of that,
His
correct?
prescription.
Would that be in her purse as well?
I think it was in her purse.
Okay. And you're aware the charges include allegations of a child and bus driver on this bus as it caught fire that she hit. You
I didn't
understand
know
that?
there was a child on the bus.
You didn't know that?
Later.
Okay. One second, Your Honor.
About your wife's substance abuse problems.
Yeah.
And one of the things that you and I talked about, did we not, was trying to get her treatment.
Yes.
And that this altercation, she was somewhat under the influence of that. I mean,
Yes.
basically attacked you for looking at somebody.
Yes.
Okay.
She's very jealous.
Very jealous. Our goal, when I say ours, that what you and I had talked about was to try to get her in treatment to address that problem.
Right.
And you would agree that this new arrest is basically based on her substance abuse problems?
Yes.
And you want her to get help?
Yes, I do.
Okay, that's all.
Step down, Mr. Miles. State may call your next witness.
Sir, please state your name for the record.
Daniel Lewis,
And she may have already asked some of this, but how do you spell it?
Daniel Lewis,
Where are you employed?
Dixon Police Department,
How long have you been employed with the department?
almost 9 years.
You recognize the individual seated beside Mr. Flanagan at the defense table today?
Yes, sir.
Who is that?
That's Miss Rebecca Miles.
Based on your investigation, do you know of any other name that she has?
Miss Rebecca Fain.
Did you have an incident with her that brings us to court that occurred on or around January the 22nd of this year?
Yes, sir.
Where was that at?
It was at the intersection of 70 and 96, sir.
Is that in Dixon County?
Yes, sir.
Now, we're here at a motion, so what exactly was the basis? Did you get a call for service?
Yes, sir. We got called to an accident involving a school bus or a private school bus and a car collision.
Based on your investigation, what did it appear had happened?
From the investigation standpoint, we believed that Ms. Miles was intoxicated during the wreck and hit the school bus, which ignited the school bus, making the child and bus driver get off the bus in a hurry.
Ms. Miles, did you ever collect blood from her, collect a blood sample for testing?
The hospital did, yes, sir.
Was that sent off, collected by you, sent off for testing at TBI?
Yes, sir.
What were the results of that for BAC?
I believe it was .113.
And was there something else in her body as well, oxymorphone?
Yes, sir.
Were people calling you about something for her? Was her family calling law enforcement?
Yes, sir.
And what about?
About a pistol we found in her purse.
Okay. Her purse?
Yes, sir.
What else did you find in her purse?
We found her prescription bottle of medication in there, along with some over-the-counter medications.
Okay. Was it, to your knowledge, was her name on the bottle? Do you recall?
Yes, sir, it was.
And the gun was in this purse with it?
Yes, sir.
Is she a convicted felon?
Yes, sir.
And what is that for?
Aggravated assault.
And to your knowledge, she also have prior domestic assault convictions?
Yes, sir.
Does she have prior domestic assault arrests?
I believe so.
Okay. That's all that I have. Thank you.
Flanagan?
Depends. Law enforcement third, sir.
Third,
Yes, sir.
I know, I've represented, so now I'm on the third generation.
Yes, sir.
How long have you been an officer?
About 9 years, sir.
Okay. And based on some of the questions that you've been asked, you would agree that she's got a substance abuse problem, would you not?
I've only met her the one time.
Okay.
So I can tell
I
you from
understand.
what I know from that case.
Okay, I understand, that's all.
Thank you, Officer Lewis.
Thank you, sir.
Where is your father nowadays?
Retired building trucks, so.
You've heard from the testimony today. In January, an incident occurred around January 22nd. You've heard proof of that before, Your Honor, involving serious allegations of Ms. Miles under .113 along with oxymorphone, striking a school bus which caught fire with a child and a driver on it who then had to flee for safety. Additionally, inside of her purse is a firearm, and she is a convicted felon with a prior aggravated assault. Both of those are B felonies with a child endangerment under 3915-401D, as well as the 3917-1307 for the convicted felon. She made bond on this, was arrested, and made bond shortly after, April 14, 2025, for a 10-count indictment, including very serious offenses, which I've noted. She was arraigned on this on June the 16th of 2025, and a mere 45 days later, we have serious allegations of domestic assault. Her husband took the stand and noted how she stabbed him with a fork in another county, but then admitted to, or spoke of, pushing and shoving while right up the hill in Dixon County. Further, he admitted that he told the officer that she said she would slit his throat. The state has serious concerns on this case. We have someone out on bond on violent offenses with a firearm as a convicted felon. And while that matter is pending and on bond, she gets a new violent offense, a domestic assault, which you heard from Officer Lewis, she has a prior conviction on. Now, I understand the defense's argument that she just needs treatment. The state is in opposition completely. Treatment will not stop this in a sense of such serious violent acts. This is not simply one DUI. No, this is a very serious offense where a school bus catches on fire and then she gets a new domestic assault with prior history of the same while she's on bond, 45 days after being arraigned in Dixon County Circuit Court. The state therefore asks that you fully revoke her bond, and I believe she's already set for a status date in October. Thank you.
Mr. Flanagan?
Well, Judge, I understand that the Assistant District Attorney is anti-treatment. This is the first time he's ever really said it on the record, but I know he doesn't like it. That's the appropriate thing here. She's presumed innocent of all this other stuff. Your Honor can leave her in this rehab center for a period of time. We can set it back when we come to court. But she's presumed innocent on everything. And the knee-jerk reaction of the district attorney, especially in this judicial district, is always to revoke their bond. They don't even consider the other alternatives, and they don't even list them in their motions. But the appropriate thing I would ask the court to consider, let these people take her back to Mammoth, Kentucky and finish that 28 days, and we can come back in and see where we are. But that's what I'd ask the court.
All right, let's talk about that. Watching work through the bond revocation hearing for was like watching a referee calmly manage a game where both teams wanted overtime. The state came in with a certified arrest record, which by statute is enough to justify reviewing bond, and they wasted no time stacking up concerns: a prior aggravated assault conviction, a school bus crash with a child on board, allegations of intoxication and a firearm in her purse, and now a fresh domestic dispute where her husband testified about a fork stab and threats to slit his throat, exactly the resume of someone the prosecution thinks should be out on bond. Their argument was blunt. Treatment won't stop serious, repeated violence, and revocation is the only safe option. The defense countered with a different pitch. Yes, she's had a string of trouble, but she's already admitted to Serenity Ranch Recovery, a dual diagnosis rehab program offering detox, therapy, and longer-term placement if needed. A counselor testified she'd been in the program a week, would stay at least 28 days, and that the court would be notified if she left. They lean he presumption of innocence, arguing that piling revocation on top of pending charges is exactly the kind of knee-jerk reaction bond law is supposed to avoid. And to his credit, Judge Wolfe didn't treat it as a rubber stamp. He acknowledged the statute gave him discretion, pressed both sides on what alternatives might look like, and made sure to balance the evidence of risk against the possibility of rehabilitation. The most striking moment came when Wolfe cautioned Rebecca's husband, Joseph Miles, about the risks of contradicting his prior statements to police. It was a careful explanation of Fifth Amendment protections and the dangers of perjury, delivered with the kind of clarity that shows he takes due process seriously. That exchange unders DGE's role here, not just referee but teacher, making sure even lay witnesses understand the stakes. Throughout, Wolfe stayed measured, letting the prosecution hammer its concerns and the defense frame rehab as a lifeline, but never letting the courtroom tip into chaos. In the end, this wasn't a story of easy answers. You had a defendant with a history of violence and substance abuse, a husband caught between fear and loyalty, and a prosecutor convinced that treatment is just a revolving door. Judge Wolfe didn't grandstand. He methodically weighed credibility, statutory requirements, and public safety. The result was a hearing that felt less like a showdown and more like a careful weighing of scales, exactly what you want when liberty and safety are in tension. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,